Hannamer C. Pugoy-Solidum vs. Republic of the Philippines, GR number 213954, April 20, 2022. Doctrine. To render a marriage void ab initio under Article 36 of the Family Code, jurisprudence dictates that psychological incapacity must be characterized by 1. Gravity must be grave and serious such that the party would be incapable of carrying out the ordinary duties required in a marriage. 2. Juridical antecedence. It must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after the marriage. And 3. Incurability. It must be incurable, or even if it were otherwise, the cure would be beyond the means of the party involved. What is important is that the totality of evidence must support a finding of psychological incapacity. In other words, the totality of evidence must still be sufficient to prove that the incapacity was grave, incurable, and existing prior to the time of marriage. The court used the Tan-Andal guidelines. 1. Psychological incapacity must be shown to have been existing at the time of the celebration of marriage. 2. Caused by a durable aspect of one's personality structure, one that was formed prior to the marriage. 3. Caused by a genuinely serious psychic cause. And 4. Proven by clear and convincing evidence. Tan-Andal v. Undal further enunciates that psychological incapacity is not a mental incapacity nor a personality disorder that must be proven through an expert witness. Ordinary witnesses who have been present in the life of the spouses before marriage may testify on the behaviors they have observed from the allegedly incapacitated spouse. Likewise, juridical antecedents may also be proven by ordinary witnesses who can describe the incapacitated spouse's past experiences or environment growing up, which have triggered one's particular behavior. In any case, the gravity of psychological incapacity must be shown to have been caused by a genuinely serious psychic cause. Incurability requirement has also been modified. Such must now mean incurability in the legal sense, not in the medical. It must be so enduring and persistent with respect to a specific partner, that the only result of the union would be the inevitable and irreparable breakdown of the marriage. Ultimately, totality of evidence must support a finding of psychological incapacity. Facts. Hannamer filed a petition for declaration of nullity of marriage on January 3, 2010 under Article 36 of the Family Code before the II.C. of Tagaytay City. She averred that Grant showed complete lack of understanding of his duties and responsibilities as husband and father during the marriage. He never worked and only depended on his older sibling for financial support. Despite not earning, Grant spent most of his time and money on gambling and going to cockfights, instead of taking care of his family. Dra. Revita testified that she diagnosed Grant with narcissistic personality disorder and that such disorder was considered grave and incurable. Dra. Revita traced back the root of Grant's disorder to his childhood, and his exposure to a tolerant and dysfunctional and permissive family setup contributed to the development of a faulty value system. Dra. Revita also testified that she was not able to personally examine Grant due to Grant's failure to respond to her request for psychological evaluation. II.C. granted Hannamer's petition and declared their marriage void ab initio. The Republic, through the Office of the Solicitor General, appealed. OSG argued that Hannamer failed to prove Grant's psychological incapacity. Grant's alleged irresponsible ways and addiction to gambling and cockfighting were not established as manifestations of his personality disorder that rendered him incapable of fulfilling his marital obligations. She also failed to identify and prove the root cause of Grant's psychological incapacity or that such incapacity existed prior to their marriage. OSG also pointed out that Dra. Revita did not personally examine Grant, and only relied on the partial and biased narrations of Hannamer. CA granted OSG's appeal. Issue: whether or not psychological incapacity was properly established. Ruling: No, psychological incapacity was not properly established. Apart from Hannamer, Dra. Revita, and the psychological report, There is no other evidence presented to support the allegation of Grant's psychological incapacity. In the case at bar, court finds that Hannamer failed to sufficiently prove Grant's psychological incapacity. The psychological report is bereft of any factual basis proving Grant's psychological incapacity. It fails to prove the enduring aspects of Grant's personality called personality structure that manifest itself clear acts of dysfunctionality. There is also no evidence proving that the alleged psychological incapacity existed prior to their marriage. DRA. Revita's findings were very general and are lacking data as to Grant's personality structure and how it incapacitates him. Neither does it prove that psychological incapacity was due to genuine psychic cause. In any case, the court emphasizes that Tan-Andal dispensed with the need for a psychological report. A psychologically incapacitated person need not be shamed and pathologized for what could have been a simple mistake in one's choice of intimate partner, a mistake too easy to make as when one sees through rose-colored glasses. There is no need to label a person as having a mental disorder just to obtain a decree of nullity, because it could very well be that he or she did not know that the incapacity existed in the first place.